Well, thanks to everyone. Thanks for the opportunity to be here. Thanks to Morty, obviously, for inviting me up. Obviously, a smaller, fairly tight group. So, just to lay out ahead of time what I've done, I've got about 20 or 30 slides that I cobbled together here in the last day or two. My thought is, as I'm going through some of these thoughts and just trying to bring a little bit of maybe move some of the federal rules out of what you've read about or dealt with in class and civil procedure, just to bring them into practice, bring them into what you deal with day in, day out in civil litigation in the U.S. But my thought is probably easiest for one and all, to the extent to which you want to just, feel free to just shoot a question out as I go along, and we can just tackle it that way. Or else, if no one has any questions, we'll wait to the end and we'll have that awkward moment where we'll say, does anyone have any questions? And no one will say anything, and then we'll all leave. So we'll do it whichever way you guys want to do it. But again, I'm delighted to be here, and I thank you all for the opportunity to speak with you. Catchy title, Electronic Discovery and Practice. Just telling you a little bit about what it is that I do for a living. I was explaining to Morty, as a partner in Kelley Drye's litigation practice, with a practice that's focused exclusively on IP litigation, I'd say about 50% of my time, day in, day out, is actually spent on electronic discovery issues. It's absolutely the fastest growing element in civil litigation in the United States right now. It's something that terrifies all of your clients, and it is something which perplexes the older lawyers that you work with who don't really know or understand anything about their computers. And I'm kind of a Luddite when it comes to the technology, but at the same time, I'm able to handle some of this stuff because at the end of the day, you just need to get your arms around it. And the earlier to you all, as you start your careers, that you, to the extent to which you're interested in litigation, that you engage the issue of electronic discovery and how it works and what kinds of issues would be presented to you, I think you'll be well served. I just pulled together 3 or 4 slides quickly here, just to give you a sense of how quickly electronically stored information, ESI, is actually growing today. This is a little bit dated from 2002, but you're seeing already the fact that back in 1999, 93% of all information generated was in electronic form. I always kind of like this stat. Again, it's fairly dated now, but basically in the year 2002 alone, newly created information exceeded 5 exabytes. And I always like, particularly again for me, to put something into practice. And if you look at it, you're basically talking about 37,000 new libraries of Congress that are created every year. And that was actually in 2002. So you can imagine that volume has probably gone up 3 or 4x. Email, the bane of every litigator's existence. Email is, you're looking right now that in 2007, the daily volume of email created is supposed to be somewhere in the neighborhood of 97 billion pieces of email. As an aside, which is actually not in this stat, which was pretty, it raises a separate issue altogether as it relates to working with clients on electronically stored information. In excess of 45 billion pieces of those 97 billion emails are actually spam. So that's another part of the world that is that's just out there, and that's a daily 45 billion count for spam. Again, getting back to exabytes, the fact that email sent annually in 2002, again doubling over the past 2 years, is going to add up to basically over 1 billion gigabytes worth of information. The reason why I say that emails are the bane of every litigator's existence is I'm sure you may have come across, if you haven't already in class, I'm sure you've come across it anecdotally just because you're interested in the law and you're at law school. Man, you will not believe the stupid stuff that people take it upon themselves to put into emails. This is Marsh McLennan got absolutely eviscerated for this. They had an email in which this was a bid rigging case. You guys all probably remember it. It basically resulted in the entire senior management of Marsh McLennan being fired. There were criminal sanctions brought, and in fact, Marsh McLennan is a completely different company today than it was back in 2004. The issue in that case was the New York Attorney General was arguing that in a bid rigging case that there was not, in fact, really a viable competition taking place by Marsh McLennan to deliver insurance services to their customers. And you can read here, he just needs a live body. Anyone from New York would do. Perhaps you can send someone from your janitorial staff, preferably a recent hire from the Postal Service. Obviously disparaging the Postal Service, but at the end of the day, Marsh McLennan wound up paying, really paying out the nose on that. Two more, again, very disheartening emails, which I'll tell you from my own practice, and I did not work on any of these three examples that I'm giving to you right now, but I've seen emails that parallel this, where you have your own clients, personnel from your own clients, executives from your own clients, writing things in emails that you just wish that they would never have taken the time to put down. Embarrassing things such as this Wyeth email, can I look forward to signing checks for fat people who are afraid of a silly lung problem? They settled that for $21 billion. Henry Blodgett, probably a little bit before some of your time, back in the .com days, Henry Blodgett was as big could be, and he actually no longer can practice in the securities industry because he took the time to, while he was promoting stocks, to also send out emails in which he called them crap, toast, and pieces of junk. And so when that all came to light, that was the end of Mr. Blodgett's career. I thought it'd be helpful to take just a minute or two just to walk through the electronically stored information that is actually at issue in civil litigation in the United States. And I should also qualify this entire talk by noting the fact that what I'm talking about here would be under the federal rules of civil procedure. There are state-by-state laws as they relate to issues such as procedure, issues such as electronically stored information. You can go through all 50 states if you like to, but for purposes of having a talk like this, I'm just talking about it for the federal rules. Electronically stored information, it's easy to think of it just as email, but the truth of the matter is that it's much broader than email. You can find ESI, electronically stored information, on phone systems, in voicemails, on hard drives. They're in MP3 players for the litigation, for example, that the Recording Industry of America has against the various folks that download and illegally file share. They're going to be on your BlackBerry. They will be found on the servers that are running at your clients' businesses. In addition, they'll be found on backup tapes, and there's an entire industry that has grown up around backup tapes, restoring backup tapes, what kind of responsibilities clients have to maintain their backup tapes. I'm sure many of you guys are familiar with the Zubulaki decision against UBS Warburg. That's all, that entire case was about backup tapes. In addition, under Rule 26, there's a distinction, as I'm sure you all know by now, between accessible and inaccessible electronically stored information. Inaccessible electronically stored information is that which has to be reconstructed, or metadata. I'm going to come back to metadata with a few slides in a second or two, because that's actually, metadata is probably the one of, if not the top 2 or 3 biggest issues that's going on in electronically stored discovery right now.